Okay, let's get started. Thanks for joining us today. I'm Ryan Johnson, a corporate healthcare attorney at Frederickson & Byron, and I'm joined today by my colleague, Marguerite Amann. And today we'll be talking about key legal issues for healthcare startups and investors. Let me share my slides with you. Just give me 1 second. All right, so quickly, as an overview, as many of you know, there's been a lot of activity in healthcare investing, for quite some time, but increasingly in digital health. And COVID-19 really accelerated that trend, with lots of healthcare providers and payers and others really trying to find ways to lower costs and improve quality through digital health technologies. Increasingly, we're seeing players like corporate investors, not just venture capitalists, other investors, but traditional providers, health systems and hospitals and payers, not just purchasing technology or licensing technology from startups or other established players, but actually investing in startups. And that's a fun trend, and I can only see that continuing. Today, we're going to cover some of the key legal issues, again, for healthcare startups. We'll touch a bit on intellectual property. Neither Margie nor I are intellectual property attorneys. We work with a number of excellent intellectual property attorneys very closely on a variety of matters, including on startups who are trying to put their intellectual property strategy together at the beginning to make sure that they don't make mistakes that could be very costly in the long run. Then we're going to talk about healthcare regulatory issues. We're talking about fraud and abuse, HIPAA privacy rules, corporate practice of medicine, talk about a bit about the FDA, and then also talk about data rights, and then finally talk about top issues and common mistakes for health startups. And our goal is to leave plenty of time for questions at the end of the session. So again, healthcare startup and investment trends, as I mentioned, there's been a ton of activity. In 2021 is a record year for investments in digital health. As I mentioned, health systems and payers are increasingly acting like venture capitalists and investing in startups. Oftentimes, those strategic relationships are very important for startups, not just because of the expertise they get from the health system or the payer about the healthcare market, but also because oftentimes systems and payers might open up other relationships with beneficiaries or patients, and startups working with established players. There can be a lot of value there from a strategic perspective. A lot of the investment activity we've been seeing has been fueled in part by the Affordable Care Act and its focus on value-based reimbursement. As many, if not all of you probably know, there is a trend away from fee-for-service reimbursement in healthcare, where you get paid based upon how much work you do, how many procedures you perform, how many scans you perform, and towards more of a value-based arrangement, where really reimbursement is tied to the value being provided to the system. Now, in order for health systems and providers and other participants in value-based care arrangements to really be effective and drive value, they really need to increase their innovation efforts, either through homegrown innovation or by partnering with the right companies. Oftentimes, startups who are finding very creative ways and powerful ways to use technology and data to find new ways of diagnosing patients, treating patients, or just reducing administrative costs. Now, again, for systems and payers and other investors, investing in startups provides an opportunity to be the first in line for many new technologies which can be deployed across systems. So a couple of words about intellectual property. Again, neither Margie nor I are IP lawyers, but a couple of pieces of advice. First, it's very important as a startup that you think about intellectual property from the very beginning. Understand what your solution is and what intellectual property will be developed by your company, what you'll own, what you'll license, and have a strategy in place. Figure out if trade secret is the best way to protect your intellectual property, knowing that certain things, like simple math or facts of nature, are not patentable. Perhaps trade secret might be the best way to protect some of your intellectual property. Of course, there's branding considerations and trademark, copyrighted software. But again, think about your IP strategy from the beginning. Working closely with an IP lawyer, although there might be some cost involved, it can pay huge dividends in the future. A couple of things I'll repeat at the end. We talk about common mistakes. All too often, startup companies fail to get the required documents in place with their employees, with independent contractors who might be developing software or other intellectual property. It's very important that you get certain agreements in place with your employees, including your founders, and independent contractors who have intellectual property that you want to have within your corporate bucket, right? That you believe should be owned by or licensed by your company. And you want to make sure you document that the right way so that if you bring in an investor in the future, or you're looking at if you're selling the company, that there is no question about who owns the intellectual property, what rights your company has to the intellectual property, the rights to use it. And all too often, companies fail to get the appropriate documents in place, and trying to get documents signed in the middle of an investment or sale event, it can be inefficient. It can be costly, and ultimately, if you don't have what you need in place, it can scare away investors or buyers. So a couple of those points again: understand what IP rights are likely to result from your company's activities and who will own it. And with that kind of IP, little primer, I'm going to hand it off to Margie to talk about some healthcare regulatory issues.
Great, thanks, Ryan. So now we're going to cover some of those more unique regulatory issues that you're going to encounter as a healthcare startup. Because just by nature of operating in the healthcare industry, you're going to be faced with a much more highly regulated set of parameters that you have to operate within. So that includes a fairly broad landscape of fraud and abuse laws, which we'll talk through, some more unique licensing and reimbursement matters, corporate practice of medicine prohibitions, FDA regulations, and then Ryan's going to touch on some new information blocking and interoperability requirements as well. So we're going to start by talking about the Anti-Kickback Statute, which is probably the most broadly applicable of the fraud and abuse statutes. It's a federal law, a criminal law, that makes it illegal to offer or receive any payment that is intended to influence referrals under a federal healthcare program, so Medicare or Medicaid. And so as an intent-based statute, the purpose behind the payment is everything. And so really you have to look at whether the payment being made is intended to get someone to use a product or service that will be in some part payable by the federal government. And if that's the case, you're going to have an issue. The government, when looking at various different activities, applies what it calls the one purpose test. So you can have a dozen different legitimate reasons to be entering into a relationship and making payments between parties. But if one purpose of that arrangement is to influence or induce referrals, then the payments that are being made are illegal. Under the statute, there are various different safe harbors. And while it's nice and cozy to operate within a safe harbor, they're fairly narrow and often don't capture all of the different kind of legitimate business arrangements that parties could want to enter. Most of the safe harbors cover various different activities and payments for services when you can justify the services as being fair market value. But I will say it's rare that an arrangement fits super neatly into one of those safe harbors, and you do not have to meet the safe harbor for your arrangement to be permissible under the Anti-Kickback Statute. So Some examples that you guys have probably all heard of in the news of kickbacks are when a doctor is paid an inflated value or an inflated amount to be a speaker at some sort of promotional event, and that is just a disguised payment to get them to actually order more of the product or service. Or if a physician is provided physical space in a facility at below market rent, again, a benefit given to a physician being disguised when it's really just a payment for referrals. There are some less clear examples or violations of the Anti-Kickback Statute. One that may be more applicable to this group are some of the allegations that have been made against EHR providers providing different incentive payments to get people to refer other clinics to purchase their EHR software. And in that case, there is a Medicare or a CMS program to give clinics EHR incentive payments. And so that is the payment from the government, creating the kickback arrangement. We'll go on and talk about Stark. Stark is a more complicated beast. It's the physician self-referral prohibition. So it's only applicable to physicians and particular types of services. But Stark is a strict liability statute. So if Stark applies to a financial relationship that you're dealing with, you have to meet one of the exceptions. So there are 11 different categories of services that fall into the designated health services. And so if your product or service falls into one of those categories, it includes clinical lab services, PT, DME, home health, hospital services, you're going to want to make sure that you're doing a very thorough Stark analysis with an attorney to make sure that whatever financial relationships exist between physicians and your company meet one of the Stark exceptions. The False Claims Act is also probably one that everybody has heard of. It's uniquely is a Civil War era statute that was originally enacted to combat fraud during by government defense contractors during the Civil War. And now it's probably most commonly used to combat healthcare fraud, or at least that's where the largest settlements are seen in the FCA realm. And this is, again, to go after claims that are submitted falsely to the government for payment. So you're going to see this in the Medicare Medicaid realm. And it does require some level of intent and some type of materiality to rise to the level of enforcement. So the example we have here on the slide is, if you make a mistake and submit a claim, you probably don't have the intent required to be targeted under the False Claims Act. But if you have sort of a reckless disregard and you make hundreds of errors, you are far more likely to get targeted under the False Claims Act. And relatedly, we have the concept of a qui tam action. And qui tam means literally in the name of the king. So the concept of a qui tam action is very similar to a whistleblower action, and it allows private persons, referred to as relators, to file suit on behalf of the government against those who have falsely or fraudulently claimed some sort of payment from the government, so under the False Claims Act. There are all sorts of incentives for people to file these whistleblower claims because they have the benefit of receiving somewhere between 15 and 30% of the verdict in the event the claim is successful. So qui tam actions are generally filed by either disgruntled employees, patients, customers, or competitors, somebody who would have had insight into false or fraudulent activities of the company and want to be able to take that to court. And I would say most commonly it's the disgruntled former employee that ends up being the relator in these actions. These claims often progress at a snail's pace. So the lead time might be 2 to 3 years, and the cases are often under seal in the interim period. Moving along, another kind of key concept that you'll want to review and assess for your business is fee splitting. Fee splitting is derived under various different state laws, usually found within professional licensing statutes for physicians and nurses and other licensed professionals. It typically prohibits a physician or the other professional from sharing revenues with non-physicians or even any other physicians than those who share a group practice with them. This is often important to assess in how you're structuring your business, particularly if you are looking to divide those professional fees. And often this plays into how management agreements are structured between a management entity and the professional entity, which Ryan will discuss later on in the presentation when he talks about corporate practice prohibitions. So just to recap, these various fraud and abuse laws are things that are very difficult to assess broadly without knowing more about the individual type of business that you're going to be starting. But key things that you're going to want to take a look at and how those fraud and abuse laws might apply to your business is looking at any sort of referral source arrangements that you are going to have. So common ones are medical director agreements, co-marketing relationships, leases where the parties might be related and somehow all involved in the business or involved in purchasing the product or service that you are selling, and possible grant or other funding that you might receive from other parties within the healthcare industry. You want to look at your fees and compensation structure to make sure that it aligns with Stark and the Anti-Kickback Statute. You're going to want to make sure that your sales force is well trained on these concepts. So not only are they operating solidly within the bounds of both Stark and Anti-Kickback and these statutes, but also that they understand the language, so they're not inadvertently making statements that raise eyebrows when all of the practices are in compliance with these statutes. And it's important to have candid conversations with your advisors, your consultants, your attorneys about how they view these laws, so you understand just how risky of advice you are getting when it comes to operating solidly within a safe harbor or an exception when it comes to these laws. One thing I think I failed to mention before is all of these federal laws that I've talked about also typically have state law counterparts. So we call those mini anti-kickbacks or mini Stark laws, which creates just an incredibly complex set of regulations that you have to work within. So it's important to not only assess what I've talked about today, but also looking at the states in which you're operating and seeing if they have similar or more broadly applicable laws that will apply to your business.
Hey, Margie, one thing I just might add in terms of, bringing in investors, and I think you already said this, I just want to make the point again. Oftentimes, startup companies, they have great relationships with, physicians, for example, or executives with a health system, but individuals who are in a position to influence referral or ordering activity. And oftentimes, the startups would like to bring these individuals in as advisors on an advisory board or join their board of directors. And sometimes there's an equity grant along with that, or they want to offer them a sweetheart deal on buying, shares or equity in the company. And, again, those kind of financial relationships with referral sources can trigger issues that should be analyzed under the Anti-Kickback Statute, depending on the nature of the business, potentially under Stark and under state, kickback prohibitions. But again, it's not only compensation, it's also, equity arrangements that can create issues under the Anti-Kickback Statute. So sorry, Mark, just wanted to flag. It's a common issue I see with startups.
Yeah, no, it's a great point, and something we'll cover later on when we talk about common issues too. Is it's important to understand these relationships when you're bringing in new investors, but also understanding how those relationships work for future investors too. Because when you have a more sophisticated investor coming in who's going to be doing their due diligence and asking questions about the existing cap table and who's invested and how they're part of the entity, you're going to want to be able to point to how you did your analysis, how it's okay and compliant under these laws, and hopefully, ideally, at that point, you also have a kind of thorough compliance plan to show your understanding of this kind of complex regulatory realm you're operating within.
Yeah, and that's an excellent point. I think that it's startups can grow rapidly by sometimes taking on more risk than other established players might. And that might be exactly the right decision for growth. It might be the right level of risk being assumed by the startup company. But to Margie's point, when you bring in sometimes larger, more established players as investors or as a buyer, some of the risk that the company took on and made sense at the time, it might be an unacceptable level of risk for a buyer or an investor. So, getting that Goldilocks zone where you're not being too aggressive or too conservative to make sure you can grow and not be overly cautious or overly conservative makes sense. But to Margie's point, again, make sure your document you're doing, you have a compliance plan in place and you can justify what you've done to a future investor or buyer. All right, so Margie, you want to go to the next slide?
Yeah, great. That's great. Thanks, Ryan. Sure. So again, this I'm going to talk about licensing. It's a very difficult concept to talk about kind of broadly without getting too far into the detail about a specific type of licensed product or service. But it's important to take a step back when you are looking at the product, service, device, whatever you are creating, and thinking through how is licensing going to impact it. Licensing is going to be state law driven. So it's going to be something that you're going to have to unfortunately assess in every single state you work in. But it's possible that your business could be regulated from a professional licensing standpoint. So you may need licensed professionals of a certain status to provide your service, physicians, nurse practitioners, physician assistants, or you might have a product or service that can be provided by individuals who don't require that licensing. But that's something that can differ from state to state. You may require a health facility license. If you're manufacturing a product, there can be manufacturing licenses, or there are even retailer licenses, commonly in the kind of audiology realm, or other areas where you're going to need to look on a state-by-state basis to see what licenses are required for you to be operating your business. And the one thing that I think lots of people get caught up on in the licensing realm is they're very comfortable with what exists in their state, and they assume that the same rules and laws will apply when they go to expand their business. So knowing kind of the intended initial footprint is key. So you can do an analysis and understand that initial footprint, but also thinking more broadly off the bat is important from a expansion plan perspective. All right, moving on to reimbursement. We could do a whole separate webinar on reimbursement, so I'm really just going to touch very high level on reimbursement. But if you are creating a product, device, service in the healthcare industry, one of the most important things for you to look at is going to be how are you going to make money from that device or product or service. And it's not as clear-cut as in other industries. You're going to be looking typically to some sort of third-party payer, and each of those third-party payers is going to have different rules that apply for both a coverage perspective and a reimbursement perspective. So that the payers that are out there in the market are Medicare, Medicaid, TRICARE, and then you have all of the commercial or kind of private payers. And then, of course, there are services where you just directly charge the patient and get your money that way. But when you think about it, you have to think about both coverage as well as reimbursement. So coverage is looking at policies from the various different payers. What are the conditions that have to be met for the service or product to even be reimbursable in the first place? And then reimbursement is what amount are you going to receive from the product or service or device once it is actually out in the market. And those may differ depending on who the payer is. And again, that's all different from state to state for Medicaid purposes and for commercial payers. Moving along, I just wanted to highlight another area that should be on everyone's radars, which are financial relationship disclosure obligations. These exist both under federal law as well as state law. The most prevalent one on the federal law perspective is the Sunshine Act, which requires disclosures from drug, biological, and medical device manufacturers for financial payments made to various different provider types, including physicians. There are similar laws under for various different states, and then there are just ethical principles for physicians where many physicians will take the position that they should be disclosing any type of financial relationship before they make a referral to a patient. All right, I'm going to turn it over to Ryan to talk through corporate practice of medicine.
All right, thanks, Margie. Most states in the U.S. prohibit the corporate practice of medicine. And what the prohibition basically does is prohibits corporations or limited liability companies or other entities from employing licensed healthcare professionals or owning medical practices. And again, this applies to many disciplines, not just medical doctors, but also dentistry and nursing. Who is covered, which type of professional, and depends on the state and the extent of the prohibition. Again, it's a very state-specific issue, which creates challenges for those companies that want to operate across the U.S. It's a multi-state operation. Again, some states don't have a prohibition, others do. And the terms and the restrictions within the prohibition, again, varies from state to state. So what are the ramifications for violating the corporate practice prohibition? If there's a physician or other healthcare practice involved, the state attorney general could get an injunction, essentially shuttering the practice. Some states, there could be criminal prosecution for engaging in the unauthorized practice of medicine. The entire arrangement. So you put together a business arrangement. You have employees. You might have third parties involved, licensing intellectual property. You might have a management services agreement, which we'll talk about briefly in a few minutes here. That entire arrangement could be declared void because it violates the corporate practice of medicine prohibition. And that means that non-competes you have in place, potentially license agreements, non-solicits, other restrictive covenants, those could all be declared void if the arrangement is structured in a way that a state licensing board or attorney general, or if it goes to court, a court could find that the entire arrangement should be declared void because it violates the corporate practice of medicine prohibition. Some payers refuse to pay claims. The basis being that arguably the services were not provided in compliance with state law. Now, there are a number of cases out there, oftentimes brought by auto insurers, where insurers have refused to pay claims again, just saying, hey, this structure you have where you have a business corporation owned by non-physicians, but employing physicians, providing physician services, we're not going to pay those claims. because the structure you have violates the state corporate practice of medicine prohibition. If the entity you're working with is a physician practice, and that practice qualifies for certain state exceptions to various licensing requirements, which can be quite burdensome and expensive. For example, certificate of need or a lab license. If those exceptions are really based upon the practice being a private practice controlled by physicians, et cetera, there's potentially a loss of those exceptions if the licensing agency within the state finds that the structure of the arrangement really puts non-physicians in control, thereby jeopardizing the private practice exception or disqualifying the practice from actually taking advantage of those state licensing exceptions. Now, many of you are probably wondering, how this prohibition actually works, because there are many examples of large corporations providing healthcare services, be it through CVS or Target or large payers employing or providing healthcare services, private equity acquisition of physician and dental practices. Well, there is a common workaround or structure that does not run afoul of state corporate practice prohibitions if it's done correctly. And that's what you see on this slide here. Essentially, what you do is set up a management company that enters into a long-term management agreement with a professional corporation that's owned by licensed professionals. So to unpack that a bit, the management company can be owned by anyone. It can be owned by physicians or non-physicians, private equity groups, other investors. The corporate practice prohibition does not apply to the management company if it only provides administrative services, right? So this management company is formed, you bring in the investors you want, and you enter into, a management agreement or administrative services agreement with a professional corporation that is owned exclusively by licensed professionals, for example, physicians. So in this type of arrangement, the management company provides a variety of services. Often provides help with marketing, tax and accounting, legal services. It often provides intellectual property, software. It does basically everything that's non-clinical in nature, and for that, it receives a management fee, often expense reimbursement and a management fee for providing, everything that's non-clinical. Everything that's clinical stays in the professional corporation, which is owned by licensed professionals. Those owners are compensated for providing professional services. It might be doctor services or dental services, and they receive compensation for those services. The licensed professional owners of the professional corporation, are shareholders. If they ever leave the practice and their shares are redeemed, they receive some modest payment for their shares. That's the basic structure that's used by private equity groups and large corporations that are providing healthcare services, at least in connection. They're providing them through an affiliated PC. But again, everything clinical is in the PC bucket, everything non-clinical is in the management company bucket. Common aspects of the management agreement I mentioned, it's long-term. If you're bringing investors in and you're trying to launch some new healthcare service, you have to do with the corporate practice of medicine prohibition. You want to make sure what you build is durable and it's long-term. If you're looking to bring in future investors, they'll want to make sure that what they're investing in is sustainable. If you're thinking about selling, you want to make sure, again, that the term of the agreement is consistent with your exit strategy. There are often pretty significant restrictions on termination. The management agreement often has non-competes, making sure that the owners of the professional corporation can't go rogue and start competing with the management company. Again, here the management company, typically in these structures, builds a lot of value. Of course, the professional corporation brings tremendous value on the clinical side, but the management company is doing a lot for an administrative side, helping build a market, doing research, doing development, investing in intellectual property, et cetera. And so there are often pretty significant restrictive covenants, a management fee. There are other agreements you put in place to make sure there's continuity of ownership. So, for example, if one of your professional corporation owners passes away, becomes disabled, or is otherwise disqualified from remaining an owner, you often have agreements in place to make sure that the shares are transferred the shares of the PC are transferred from the exiting owner to a new owner so the management company can keep doing business. All right, just a couple of brief words about the FDA. So if your startup is developing software or a new algorithm, so some sort of digital health algorithm, depending on what that software does, it could be considered to be a device as broadly defined by the FDA. If it is defined as a device, it's possible that the software could be subject to some of the burdensome and costly requirements of the FDA. Now, the FDA has been encouraging innovation. It's exercised enforcement discretion, treating some apps, some software platforms that would otherwise be treated as a device as they don't regulate them the same way as they could, given the language of the regulations in place. They've also passed guidance recently to provide some clarity for startups and digital health companies, knowing what what software platforms will not be treated as devices, and those that are technically devices, again, will be under this sort of enforcement discretion under the FDA. Now, the 21st Century Cures Act from Congress and again, some regulations that followed have also carved out certain software platforms from the definition of device, again, providing more clarity and a clear pathway with less cost to startups in the digital health space. Kind of the takeaway here is you want to make sure that if you're creating a product, software or an algorithm that could be viewed as a device, you work closely with a lawyer who understands the FDA rules to make sure you understand your obligations under the FDA. And with that, Margie, I think you're going to talk a bit about health information privacy.
Yeah. So yet again, another patchwork of regulations that you have to be thinking about. Almost every healthcare startup that I can think of somehow deals with health information in some shape or form. And so it's important to look to the various laws that I have on this slide to see what your obligations are with respect to keeping that data safe and protected, and only disclosing it in a manner permitted by law. So you have HIPAA, which everybody I'm sure has heard of. It's also making a bigger name for itself these days with the number of people who are raising HIPAA as a justification for not sharing their vaccine status. But that is a talk for another day. I will note it is HIPAA with one P. The easiest way to show that you do not know what you're talking about is spelling HIPAA like hippo with two P's. There's also 42 CFR Part 2, which is another set of federal regulations governing health information, but specific to substance use disorder records. Then you have a state, almost every state has some law that will apply to medical records. And then certain states have taken a much more aggressive position on regulating information, personal information more broadly, and then a lot of that touches on health information too. So one example is the California Consumer Privacy Act, the CCPA, has implications for health information as well. And then if you are operating internationally and deal with, if your clients are EU residents, then you'd also have to look to the GDPR. I am going to focus just on talking about HIPAA today, since it is the most broadly applicable here. So HIPAA is going to apply to healthcare providers directly, and other types of covered entities is the term used under HIPAA. So those include providers, like I mentioned, plans, and healthcare clearinghouses. And then it also applies to business associates, which are third parties who contract or deal with those covered entities and use protected health information in the process. So Ryan, if you go to the next slide, I'm going to cover just what the kind of big core compliance requirements are for HIPAA. Those include having a very thorough set of HIPAA policies and procedures. These core requirements apply whether you're a covered entity or a business associate. So it's important to make sure that you are having really good hygiene with your health information, but also making sure you're documenting what those policies and procedures are. You have to train your employees on HIPAA. There is no explicit schedule to how often you train employees, but you have to train them upon hire, when their role changes fundamentally with respect to health information, and then periodically thereafter. So that's why you see most healthcare providers doing at least annual HIPAA trainings. You have to do a security risk assessment. You have to have a process for handling any sort of breaches of PHI. And then you have to have business associate agreements in place. So this is for covered entities. They have to have business associate agreements in place with those business associates. But if you're a business associate, you're also directly liable under HIPAA for having those agreements in place as well. So moving on to the next slide, the most common mistakes that we see people making from a HIPAA perspective, and ones that OCR, the Office for Civil Rights, takes particular issue with, is failing to have BAAs in place. It's particularly important to have those in place from the very beginning of a relationship, before any sort of PHI is exchanged between a covered entity and a business associate. Having your security audits, your risk assessments in place, and not only having done one, but having done it and documented it incredibly well. Social interactions often tend to be a kind of easy opportunity for leaking PHI or protected health information. Social media has become kind of commonly an area where employees are sort of inadvertently, but making disclosures that would not be permissible. A common example is if somebody writes your new business a horrible review, you cannot, in responding to their review publicly, disclose any sort of PHI in the process of responding. And portable devices are kind of the key thing. If somebody takes a laptop off the premises, it seems kind of guaranteed that will be the time that it is then stolen from a vehicle. And so you want to make sure that you've had good security protocols in place, so that way your portable devices are encrypted and not in a position to lead to a breach, even in the event they are stolen. I have a few HIPAA myths on the next slide. We'll just go through a few of these. A couple of my favorites are the fact that people often think if they just redact the patient's name, it's no longer PHI, when in fact there are 18 different identifiers under HIPAA, and you would have to strip out all 18 of those identifiers for something to fall under the safe harbor under HIPAA for being de-identified. I'll touch on this last one too. The idea that you purchased HIPAA compliant technology. So as a startup, you're probably going to be doing as much in-house as you can, but also bringing on vendors who have their own specialized area, providing different software. And so in the healthcare industry, you will see things advertised as being HIPAA compliant. That always is an area that is kind of suspect for me. One, because any technology can be used in a non-compliant manner. So you can't just take software that a company has assured you is HIPAA compliant and then not worry about HIPAA compliance. And the other thing is, I think that's just a very bold statement that should be assessed more thoroughly. So with that though, we'll turn it over to Ryan to talk about it.
Yeah, thanks, Margie. And before I start talking about the next topic, just a couple of maybe questions, Margie, and scenarios that actually come out of the OCR, the Office of Civil Rights. One thing I see, and you might too, is confusion over when a software developer or an app company is a business associate. I think that the reaction that many covered entities have is to have everyone sign a BA. It's right. It's the safest course. Just have them sign it if you think they might possibly come across protected health information. So these are some scenarios that, again, come out of the OCR. I'd like to get your thoughts. I think it might be helpful for the listeners here who might be developing a healthcare app of some sort. So here's the first one. A consumer downloads a health app to her smartphone. She populates with her own information. For example, she inputs blood glucose levels and blood pressure readings she obtained herself using her personal home health equipment. In this case, is the health app a business associate of anyone?
No. So this is a great example. So if a company that on its own is not a covered entity, so the health app developer is not a healthcare provider, it's not a health plan, it's just an independent entity developing this app, they're not going to fall under HIPAA as any sort of covered entity for regulatory purposes. And a patient, and it's sort of a misnomer to call them a patient, it's just an individual out there, is able to give their health information to whoever they want. And just by nature of providing your health information out there does not mean the other party has to protect it. But it is a common misconception. So short answer, no.
Okay, let's take the kind of the same scenario, except now the individual, also a patient, takes all the information from the app and she feeds it to her physician or through the EHR through a patient portal. So now in this case, you have the information from the app being provided to the provider by the patient. Is the app developer business associate?
No, because again, in this scenario, the developer is providing an app to a patient and not doing it on behalf of any sort of healthcare provider. So the patient, the individual is taking her own initiative to provide that information to her provider. Once the provider has that information, the provider has to protect it, but nothing about the health app and that relationship between the app developer and the individual has triggered HIPAA to apply.
Okay, it's going to change the scenario a bit. In this case, let's say that the app the patient used was actually at the direction of her provider. So provider said, here's an app you should use. Down to your smartphone, input your blood glucose levels, your blood pressure, etc. And the provider has a contract in this case with the app developer to provide these patient management services. In this case, is the app developer a business associate?
In this case, the app developer would be. So the key difference here is now the app developer is providing a service on behalf of the healthcare provider. And the healthcare provider is a covered entity under HIPAA. And so by providing any sort of service on behalf of the provider where they then have access to PHI, assuming the app developer has access to that PHI, would make them a business associate.
Okay. All right. Thanks, Margie.
Mm-hmm.
All right. So information blocking and interoperability. I'm not going to say much about this, but the 21st Century Cures Act, which I mentioned earlier, has a number of provisions, and there are now new rules that are designed to provide seamless and secure access, exchange, and use of electronic health information. One of the biggest barriers to health innovation, according to from the perspective of many policymakers and innovators, is these silos of data that really can't be shared because systems aren't interoperable. So there are new interoperability rules that will help make information flow more freely between providers and payers. But also there are new information blocking rules, which are designed to give patients and others greater access to health information. And so with patients now having, Fitbits and other remote monitoring devices, working with a variety of apps on their phones, they have a better ability to get access to this data and share it with developers, share it with app companies. And, there are many opportunities here, I think, for startups to find creative ways to get access to very powerful data that can be used to empower patients to better manage their health, can be used in a variety of ways to hopefully, again, reduce costs. But if your company is looking for ways to get data, these rules might provide, again, a pathway that wasn't there before. I want to just make a comment that it's going back to Margie's Hipaa presentation. So many startups in the healthcare space, digital health space, are using artificial intelligence and machine learning to train algorithms that will, again, help diagnose or treat various health conditions, help reduce costs, etc. And what these developers need is lots of high quality data. And some of the entities or companies that have this data are covered by Hipaa, or they're covered by other state or European or other international privacy laws. So what some developers are doing, one, you can go through the process of getting the information if it's de-identified as defined by Hipaa. But another model that developers are using in companies is one that's known as the federated learning model. The way this works is the company with the AI-powered software algorithm will basically train it on site at the provider or other covered entity. So data does not leave the provider's servers and then go to the developer's servers. All the training takes place at the provider location or the covered entity location. Once the algorithm has been trained on this data, it's sent back to the developer. And this process can go on over and over again with different providers. Hence the federated learning model description. But that can be done in a way that there's no sharing of identifiable data with the developer. And that's a model that's worth considering if you need to train an algorithm that's using machine learning. You want to do it right to make sure it's structured to comply, of course, with all the rules and regulations we've been talking about. But it is a model that is gaining more traction in healthcare. It's not new to software developers. That model has been used in software development for quite some time, but it's increasingly taking hold, I think, and getting some traction in healthcare.
So Ryan, you bring up a great point too, that goes to that Hipaa analysis, because if someone is not working in healthcare directly, but is a business associate, it's going to be sort of a black and white. You're either a business associate or you're not a business associate. But not all business associates are created equal. The amount of PHI that you handle and how you handle it will severely increase or decrease your risk, and your risk of some pretty significant and large enforcement penalties that have come down from OCR. To the extent you can think through your business opportunity and think, can I do this with less PHI, or can I do this and keep the PHI on my client systems, as you just suggested, is incredibly beneficial from a risk mitigation perspective.
Yep. All right, so a couple of comments about digital health and data rights. So, just briefly, as I mentioned at the beginning of our presentation, digital health continues to be an area where there's significant investment activity, significant activity in terms of what providers and payers are doing. Patients or consumers are really adopting digital health tools. This accelerated during COVID. The best example being telemedicine, of course, when various licensure requirements were suspended. various rules were waived or changed to make it easier for providers to provide telemedicine to patients and get paid for providing those services. When people talk about digital health, broadly, they're talking about really an ecosystem where you have health apps, IoT connected devices, automation and robotics, consumer apps and wearables like Fitbits or Apple Watches, health IT services, telemedicine, and a variety of medical algorithms. And of course, what's common to all of these and their ability to actually provide value is their use of data. So again, neither marketing or intellectual property or data rights attorneys just want to flag these concepts for you because they're very important for any digital health startup. First of all, you have to know what types of data you need for the solution you're building. You have to know how that data will be used in your solution. Importantly, you'll have to know whether there are any restrictions on the data, on data use. And that could be through a business associate agreement if you're getting data through your relationship with a provider or other covered entity. It could be through an agreement you have with a non-covered entity. Just the contractual terms might limit how you can acquire or use the data. There are your notices on your website or on your app that describe how you use your data. You use your consumer data. Those are important because if you breach those, there could be consequences through the FTC or otherwise. And this is important for you to know so you do it right from the beginning in a compliant way. But it's also going to be important when you start talking to sophisticated investors or potential buyers of your company. If data is central to how to the success of your company, to the value of your company, a buyer or investor will want to make sure you can use it in the way that you need to, right? And there aren't restrictions in place that could complicate matters. So data considerations when you're contracting. Again, think about who will provide the training if you're using AI or machine learning and input data. If you're using public data sources, again, understand if there are any open source data, understand any obligations or restrictions that come with using open source data. Let's skip ahead. Talk about some other key terms, data and privacy and security. Obviously, privacy is huge. Margie talked about some of the rules and regulations under Hipaa and otherwise. Security is also incredibly important. Every day we hear more and more about cybersecurity incidents. Those can be very expensive, and investor or buyers will want to make sure you have the right security safeguards in place. They'll come during due diligence. There'll be reps and warranties in contracts or financing documents. If you have contracts with customers, you want to consider what happens to data once the contract is terminated. You get to retain any of the data. Do you have future access to the data? Some of that will be driven by various rules and regulations. Some of that will be driven by the contractual terms you put in place with your customers or third parties. All right, so with that, maybe we can just break from the slides here and talk about some other common issues. All right. So, Margie, what are some of the common issues you see?
Yeah, I think from a startup perspective, so if people have engaged in other industries and been part of startups in other industries, and then this is their first venture into the healthcare industry, I think it can be hard to orient yourself to this world of highly regulated fraud and abuse considerations, particularly from a marketing perspective. What works in other industries to provide incentives and promotional materials to get your product being used and getting word of mouth out there doesn't work in a straightforward, at least not in a straightforward manner in the healthcare industry because of all the concerns around fraud and abuse and overutilization of the healthcare industry. And so I think making sure that everybody who's on your core team of founders thinking through how your product and service is going to be marketed really has a fundamental understanding of the restrictions in this industry is key, so you don't end up kind of unbeknownst to you getting yourself into a very kind of sticky situation when it comes to these laws. I think that would be my kind of first piece of advice. How about you, Ryan?
No, that's great. And, you know, the other one I mentioned earlier is just not having the right documents in place with employees or contractors to make sure you protect your intellectual property. It happens all the time. So make sure that you have the appropriate IP assignments in place and you have documentation of your ownership. You don't have to try to track that down, have people sign documents or pay them, some sort of hostage fee to get them to sign during a financing or future sale. Another issue is not health law related, but it's really the cap table, with founders. It's, oftentimes at the beginning you have founders who come and go, right? You sit around, you have a great idea, you're building a company, and one of the founders leaves or multiple founders leave, or are there key employees who were there at the beginning. And there were conversations about offering equity, back of the napkin promises. And it's unclear who owns equity, who was promised equity, because the company hasn't done a great job sort of tracking ownership and documenting, promises to issue equity. That's a very common problem, and that's enough to, kill a deal. That can really scare away investors or buyers. So you want to make sure you're clear from the beginning on who's going to own equity, who has an option to acquire equity, and what those terms are. And again, this is easy enough to do. You just have to make sure you do it and work with your lawyers to make sure you have the right kind of documentation in place. Just one follow-on topic, Margie. We talked about earlier. Just want to again mention that you'll want to bring in oftentimes strategic advisors. People who have great connections in the market, be it with providers, payers, device companies, etc. Make sure you remember everything Margie talked about the Anti-Kickback Statute, the federal Anti-Kickback Statute, state equivalents, to make sure that the equity you're offering couldn't be construed as a unlawful remuneration, an unlawful kickback to generate referral activity from those individuals. You often want them in your orbit. It adds credibility. You get great advice. They can open up networks, but you have to do it the right way.
So we have one question about if somebody's goal is to provide IT services to healthcare companies, what are the key things to have in line? And I think this kind of pairs nicely with another sort of issue or mistake that I often see is with organizations or businesses that are geared towards IT or security. Sometimes they are so focused on making sure that they have all of the best security measures in place, which is the right thing to be doing, but that they fail to actually take a step back and make sure they've also documented the core kind of fundamental HIPAA requirements. Because again, it's not just about what you've done, it's also about what you've documented. And so for particularly those businesses that are going to be providing support services to traditional healthcare providers, think about it from the traditional healthcare provider's perspective. They're going to be seeking a new vendor. They're going to see you as a great new IT management company. They're going to think, okay, this is great. I'm now going to perform due diligence on this new company and make sure that they're going to meet all of our regulatory requirements. They're going to think through HIPAA and other state laws. They're going to provide a kind of basic questionnaire, or if it's a large health system, it could be a very detailed questionnaire about how you're meeting those requirements. And so making sure that you not only feel very confident about the way you're going to handle their health information, but also being able to say, hey, look, here are our policies and procedures, and here are the other things that we have in place. Here's how we check all of the boxes. You do not have to worry. We spell HIPAA with one P. We know what we're talking about. And you don't have to be at all concerned with how we're going to handle it. So to answer the specific question that came in, I think as an IT vendor, HIPAA is probably going to be your number one priority in terms of being able to showcase your compliance to your future clients. but also having a broader kind of compliance plan that talks through some of these other kind of fraud and abuse components is also still important, even when you're providing an ancillary service. They're also still going to be concerned as a contractor whether you've screened your employees for exclusion under the OIG list and all sorts of other kind of ancillary laws under the healthcare realm. I sort of hate that I just threw out an extra one we didn't talk about, but that's why you should have a good advisor to kind of fully scope out the legal implications. Ryan, anything else that you'd add to that IT vendor?
Well, I have a follow-on to your last comment. I think it's, making sure you have good advisors, right? You want to build a team. And one mistake that I see startups make is not bringing in lawyers soon enough, right? And they structure things, they're trying to, bootstrap things. They don't want to hire a lawyer, and they can make compliance mistakes at the beginning that can be very costly, right? They can, or they can build a model that just isn't going to work because they haven't talked to a lawyer to understand that you can't do this under HIPAA. You can't do this from a fraud and abuse perspective. You can't get reimbursed whether you think you're going to get reimbursed because of these requirements. So that's on the healthcare regulatory side. There are also mistakes that can be made in terms of choice of entity or how you handle founder stock from a tax perspective, where you can have significant benefits if you structure things the right way at the beginning. So you want to make sure you engage the right advisors, be it legal, tax and accounting, early on. Obviously, startups often don't have a lot of cash, and you have to be smart about how you spend your dollars. But really, healthcare is extremely regulated, and there are lots of mistakes that can be made that can be fatal to a business. Now, one thing our firm does, we have a program called Surge for Startups. We work with a lot of startups, and that stands for Startup and Rapid Growth Enterprises. But kind of getting the basic blocks in place at a very low price. We work with startups all the time. We're efficient. We want to make sure that we get our clients pointed in the right direction from the beginning. So there isn't a lot of cost and hassle down the road trying to fix things. And sometimes you can't fix them, right? There's not a way to fix some tax problems that were created or HIPAA problems that were created at the beginning, at least not in a way that makes economic sense. One other mistake I often see made is startups, they have the opportunity to partner with a great strategic partner. It could be a payer, a device company, a pharma company, provider, and the clients rightly excited, right? Because there are some great opportunities, that you get some great expertise, knowledge sharing. Potentially you can open up different relationships through that strategic relationship. But the contracts that are put in place are sometimes very one-sided. If that relationship ends, the strategic partner who brought a lot of value at the beginning, or seemed like they would, they might now have a lot of rights that the startup will surprise the startup, right? There might not be a non-compete in place or non-solicit. They may have given away intellectual property rights. They may have given up valuable data rights. So again, it's important if you're structuring a relationship with a strategic partner, you engage, the right advisors, legal or otherwise, to look through those contracts to make sure that you don't give away the farm. And when you're striking these deals with the large players who are very sophisticated and often write contracts that are sometimes imbalanced for their benefit.
Another thing that is probably worth mentioning too, it kind of goes back to my first comment about how the healthcare industry is just fundamentally more complex than a lot of other industries, is this idea of, you may see somebody out operating in the market and it looks like they have a fairly simple model. And you want to do something similar but slightly different, and you're going to just replicate the model. This is an example would be some type of specific telehealth service, and you see somebody else providing telehealth, and they're providing telehealth in what appears to be all 50 states, and they're doing it under one brand. And so clearly there must be a way for your company to be able to go out and do that. I will warn you that it is often far more complex behind the scenes, or not everyone is operating within the parameters of the law. So two sides to that. But on the side of it being more complicated than it seems, this goes to what Ryan was talking about earlier on corporate practice prohibitions. Often what looks to consumers like one brand operating all over those quick clinics or telehealth providers is actually a very complicated patchwork of state professional entities that are linked by way of management agreements to those national brands. So just as Ryan talked through that arrangement, but they don't have to spell that out to consumers in an incredibly flagrant way. So just know that talking to advisors early is really key, because they can help sort of weed through what others are doing and how they're doing it, and help you see how it's probably doable, just could be a lot more complicated than it looks at.
Yeah, and just adding to that, you want to make sure you pick the right advisors. So you might have to talk to a number of different lawyers or other advisors to find the right fit. Some lawyers are too cautious, too conservative. That's not a good fit for a startup company that's trying to, they can't necessarily spend all of their dollars on compliance activities, right? You have to right size your compliance approach. Working with the lawyers, identify the high risk areas, the right compliance approach, to make sure you don't spend every dollar you have in your bank account on lawyers and compliance issues, right? And lawyers who work with startups and digital health companies and healthcare companies, can help you tailor your compliance efforts to make sure that you get going, in the right way at the beginning, without layering on unnecessary compliance costs or burdens that can, make it very challenging to succeed. I think that's what I have for top issues, Mark. I'm not sure if you have any others.
Yeah, I think we covered other things earlier in the presentation, but I'll maybe hit on one other again, which is just, for a lot of startups, the end game is a buyout or a sale, and so having your house in order as you build it is a much more efficient process than having a messy house and scrambling to get it in order just before that large deal goes through. So making sure that you're thinking through these things, documenting how you're applying and analyzing these various different compliance requirements is key to being in a good position for that ultimate sale.
Well, unless there are any other questions, that's it. Well, thanks everyone for listening to us today. Feel free to follow up with either of us if you have any other questions. Enjoy the rest of Startup Week. It's always a lot of fun, lots of activity, lots of great sessions. So have fun.